Okay, welcome to my channel. This is Mr. Al. Now I will talk to you about leading maritime lawyers about Houston Maritime Attorney. We serve injured maritime workers nationwide, offices in Texas and Louisiana. Just like any other industry, seamen are at risk for suffering work-related injuries anytime. They are on the clock. The court recognize this and are continually working to protect injured seamen through general maritime law. Maritime laws gives workers who have been injured offshore or in the maritime industry the chance to claim necessary compensation for any suffering medical complication. The following acts are foundational to maritime law: Jones Act, Death on the High Sea Act, Limitation of Liability Act, Longshoremen and Harbor Workers Compensation Act. General maritime law is the basis of all injuries sustained by seamen. It is important to have a comprehensive understanding of the general law before delving into the subsequent act. History of Admiralty and Maritime Law. Maritime law, also referred to as Admiralty law, is nearly as old as the shipping industry itself and governs most accidents that occur on navigable waters. The law's root can be traced back to the unwritten customs of nautical behavior of the Egyptians and Greeks. However, the earliest formal coast was established in around 900 BC on the Greek island of Rhodes. The original maritime laws and codes stem from ancient customs and rules of shipping. For example, the doctrine of general average, the concept that all sea cargo stakeholders, owners, shippers, etc., evenly share any damage or losses that may occur as a result of a voluntary sacrifice of of the vessel or cargo to save the whole can be traced back to the early shipping customs of the Rhodians. The concept of a separate legal authority regulating maritime issues was brought to the West by Eleanor of Aquitaine, who learned on this concept when she accompanied her first husband, King Louis VII of France of the Mediterranean on the Second Crusade. The term Admiralty law came from the British Admiralty courts who presided over maritime matters separately from England common law courts as the U.S. judicial system is based on the British system. Maritime admiralty laws were gradually incorporated into our legal system soon after the Constitution was ratified. Through seal based on the industry standard and custom maritime laws is largely found in the U.S. Constitution, treatises, and international conventions, federal statutes, the general maritime laws, and other judicial decisions, administrative regulation, and custom. When does maritime laws apply? Perhaps most obviously, maritime law applies to events that occur on high seas. In other words, accidents that happen beyond the territorial water of any country. Furthermore, maritime law applies to the territorial sea, which are rather within 12 miles of the shore. However, the law's applicability becomes less clear further inland. Early in the United States history, maritime laws didn't apply to incidents that occur with the body of the country and therefore excluded incidents involving the Great Lakes and non-tidal inland waterways. However, throughout the 19th century, this exclusion eroded away. Maritime law is not applied to navigable water. A waterway is deemed navigable by itself By uniting with other waters, it can serve as continued highway over which commerce on May can be carried on with the other states or foreign countries. Consequently, if a body of water completely landlocked with a single state that is not navigable for purpose of admiralty jurisdiction. However, a body of water does need to flow between states to be deemed navigable. A body of water may be deemed navigable if it is a link in a chain of bodies of water that can be used to service interstate commerce. Ultimately, the test is that the commerce of one state must be capable of being carried into another state of a foreign country. Once this test has been passed, it is likely that maritime law will be applicable, even if it is a recreational vessel. Incidents that require Texas Maritime Accident Attorney. Houston Maritime Injury Attorney exists to help injured seamen or dock workers get the compensation they need to recover from serious injuries and afford long-term medical costs that occur offshore. That include any accident that occur on navigable waters, rivers and oceans, and in water, harbor or docks. Our maritime lawyers have represented clients who were injured in accident. One notable aspect of maritime accident is that they are often devastating. Offshore oil rig explosion can significant damage, vessel collision, and frequently catastrophic. An oil platform can unfairly change the life of workers. Maritime lawyers fight to help workers recover the compensation they deserve. Whether they're suffering after a major explosion or have injuries caused by unsafe working conditions. Our attorney represented more crew members of the Deepwater Horizon and the El Foro than any other law firm. We not only understand maritime law but the practice and culture of maritime employers. Speak with us to discuss your case so we can go over your legal and financial options. The basic of maritime law. Maritime law is derived from many sources, federal statutes and general maritime law being two of the most prominent. These sources provide some of the maritime doctrines that are commonly used in cases involving vessels and their passengers and crews. Maritime law set forth many of the basic legal tenets associated with the sea and seamen, including seamen's right to maintenance and secure, the Jones Act, the Canal High Sea Act, the Saving of Sailors Clause, Longshore and Harbor Worker Compensation Act. Thank you for your attention.